awake yet this morning. I see the recording light is on, so good morning, everybody, or good afternoon. Good morning in California, good afternoon everywhere else. Much like our federal call, the California call has low representation today, and I'm attributing a lot of that to the fact that everyone's gearing up for tomorrow. I don't know if any of you heard, but tomorrow's election day. Oh, I see our friends from JB's here, so there's another jump in. But tomorrow's election day, which is keeping everybody hopping, everybody jumping. Here in New York City, they're boarding up the windows, so that tells you what they're thinking about here. Nevertheless, there are still things happening in California that are important to the rest of the country. We are lucky to have not only Chuck with us today, but Matt, who has a flat on the side of the road, who is on mute. Has dialed in at least. So let me first introduce who's with us. Brian and Avis, client relations. Hank, our guru on all things business. And we've asked Rick, our subject matter expert on manufacturing and NFA, to join us today because I want to talk a little bit in California about arm braces. We had a huge talk about that on the federal call. So I wanted to carry that arm brace conversation over into the California call. But to get things started, let's turn it over to my boobala, Chucky boy. Tell me what's on your mind as the California expert there.
Well, from the macro level, we're looking at litigation strategy, and the answer to our prayers is hopefully sitting on the bench right about now. Actually, she's probably just breaking for lunch. In the United States Supreme Court with Justice Barrett now making John Roberts' swing vote less critical to getting a Second Amendment case in front of the Supreme Court and getting the standard of review clarified and teeth put back into the Second Amendment so that we can use a more critical level of scrutiny being applied to all manner of ridiculous gun control laws to strike more of them down. So we still got Rhodey's the challenge to the ammunition background check law that we won in district court. It will be in front of the Ninth Circuit panel in about a month. We haven't heard who the panel is yet. But we're hopeful that we'll get a couple Trump appointees or conservative justices. Then we've got Duncan, which we won the 3-judge panel. We're still waiting for a ruling on the en banc request that the state made for a larger review by the 11-judge Ninth Circuit panel. So that panel has not been assigned yet. They're drawn at random. Then we've got the Roop case, which is or has been briefed and orally argued in front of a very frankly favorable 3-judge panel in the Ninth Circuit on appeal, and they were very critical of some of the arguments that the DOJ was making about why the so-called assault weapon law is constitutional. So those 3 cases are sort of leading the charge. It'll be very interesting to see what happens if we hold on to those en banc. Becerra will be, the Attorney General, be in a very unusual situation where he's got to decide whether or not to appeal that loss to the Supreme Court. He will find himself in a situation like the District of Columbia did when their May issue system was struck down, and they decided not to ask the Supreme Court to hear about that loss. They decided not to appeal their loss because they didn't want to set national precedent. What'll probably happen, unfortunately, and Chris, I want to talk to you about this later. We may need to try and get ahead of this curve. Some unqualified lawyer is going to see that there is now, if we hang on to Duncan or Rhodey or Roop, some unqualified lawyer in another jurisdiction is going to see that there's now a opportunity to create a strong, or there will be a split of authority on 10 plus round mags or assault weapons or ammo sales, and will file a case in one of those other circuits with an eye towards losing their way to the Supreme Court so they can, be in the show. So that's my big fear right now, is that some knucklehead is going to think that he's qualified to litigate these and go in front of the Supreme Court. So we're trying to get ahead of that. We're actually looking in other jurisdictions where we've lost these cases to try and gather up plaintiffs. And in fact, maybe we ought to come on the, I don't know when the next national FFLGuard call is, but we might want to come on and talk to them about this. Anyway, so it's good news, but it's still edge work. We have to be careful, and we want to try and hang on to those wins and make those and lock those wins in nationally. So I think that's about it on litigation. I'll let Matt talk about regulations.
Is somebody holding somebody captive? I heard screams of captivity in the background. What was that all about?
Yeah, so I'm here at America's Tire. I'm getting my tire fixed, and there's some homeless guys screaming in the background. So hopefully it's not too annoying.
Right, I thought maybe some had, Chuck had a little footlocker with the gimp in it there.
Yeah.
Yeah. So, okay. What's going on, Josh? You're on mute, by the way.
Oh, Matt.
I'm glad to see Josh is here.
Oh, Matt,
I see him this week. I can actually see him, so that's good.
Yeah.
So other than the screaming men in the background, what's up, Matt?
Yeah, so I just wanted to touch briefly on, I know this is a question that some of the dealers in California might be asking with the impending election. As many of you have experienced or at least saw in the news following the riots a couple months ago, there were some issues here in California where some California-based FFLs were unfortunately looted and had much of their inventory taken. The ATF essentially came out during those riots and effectively told California dealers to do what they had to do to secure their inventory, which could include taking your firearms off-site temporarily if necessary. Unfortunately, the problem here in California is that we have also to deal with the DOJ, and in reaching out to the California DOJ, I tried to get some clarification from them, basically explaining this to them, and spoke with their attorneys on this, and they agreed that it was an important thing to do, but of course we never got a response or any guidance from them as far as what to do in the eyes of California regulations. So this is something that some of you may have to be worried about, may have to consider depending on the outcome of the election tomorrow, depending on what happens and if it's something that you guys are seeing, unfortunately unlawful riotous activity in your areas, you're going to have to consider what to do. And so what I'm going to be doing, just to give you guys a heads up, is I'm going to reach out to the California DOJ again today to try and, make sure that they're thinking of this, but also to hopefully to get a response from them. And if we can, ideally get some, cover for you guys, that if you guys do want to secure your inventory for whatever reason, if you feel it's necessary, that you're not going to be subject to reprisals from the California DOJ for taking your inventory off-site if that's what you feel is necessary. So stay tuned for that. I'll be trying to reach out to them today, hopefully get a response, obviously, before the election. But that being said, I'm not going to tell you guys that depending on what happens, if it's something that you're facing a situation like that, I would say do what you have to do and do what you think is reasonable, and hopefully DOJ doesn't give you any flack for it, especially if it's something that ATF is telling you to do that anyways. So just something to think about. I know it's not pleasant, but just be aware of that and keep us advised if it's something that you think that we can help with at all. Just feel free to reach out and let us know.
Well, it sounds to be from JB down in San Diego that California DOJ is pretty hard and fast about you can't take. We don't care what the feds say. You can't take your firearms off the licensed premises, which is not surprising. Right. The very reason why we have you guys with us, because, federal rules don't matter there. So, JB, thanks for that input. But it seems as though, you have to make a hard decision sometimes as to what you want to do. And let's be fair, there's some stores where you can't move. They're so big, you're not moving everything out of the store. So you better fortify your defenses and hope your operational security is intact. But no, we appreciate that input, Matt. Josh, I don't know if you have, if you want to close the loop on the three amigos from California, but your floor time is now.
All right. Well, hello, everybody. So last week, we talked a little bit about ADA violations and how that may affect you guys as retail store owners who have websites. I imagine everybody here has a website. And so I want to go over that briefly and what the potential liability is for you folks in California. I'll preface it by saying some of you may have been around for the Prop 65 plaintiffs lawsuits. Some of you may have been hit with ADA physical accessibility lawsuits where there's a serial plaintiff who goes around and he surveils a bunch of stores, and then you get a lawsuit along with a bunch of your neighbors in your shopping center claiming that you don't have enough handicap parking, or the van parking isn't wide enough, or your doorways aren't ADA compliant. And so these have been going on for a while. These have been going on for at least 15 years. But recently, back in the early, I want to say 2011, 2012, there were web content accessibility guidelines issued by one of the organizations that runs the internet. And subsequently, under the Obama DOJ, they ended up claiming that these web content accessibility guidelines, as a matter of not regulation, but as a matter of guidance, these accessibility guidelines should be implemented for all retail websites. And what these guidelines do is they allow blind people to use web browsers to access your website. And typically what they have is they have verbal cues that will go off that will describe what the person is supposed to be seeing on the web page. And so where this comes in for you folks is about 3-4 years ago, plaintiffs' attorneys saw these guidelines, had the prior success with the ADA physical accessibility lawsuits, and started filing ADA website accessibility lawsuits. And now that has become a hot thing in California. We've had multiple clients get hit with these things. Usually they settle for anywhere from $5,000 to $12,000. And it's a shakedown very similar to the physical accessibility lawsuits and the Prop 65 lawsuits. So what can you do as business owners to not get caught up in one of these? Because this is easier for plaintiffs' attorneys to file than the physical accessibility lawsuits. They don't even have to drive by your business. They can just Google you. And they are hitting retail sporting goods and firearms dealers right now. We've had a couple. The way you protect yourself is you have to get your website certified to this WCAG, the Web Content Accessibility Guidelines, version 2.0. And the way you do that is you have to go out and hire a web developer who has experience with that, who will go in and then tag your website with all the code needed so that when somebody who's blind accesses your website, they can hear all the products you have to offer. Now, this can be somewhat onerous because as your product line is potentially changing, you're going to have to either hire somebody or learn yourself how to tag your website so that when you put a new product on, it has the code so that it's still WCAG 2.0 compliant. But that's really the only way you can avoid these lawsuits. There's been several test cases in the California courts of appeal and even in the federal district courts that have basically blessed the DOJ's recommendation as being correct, as correctly interpreting what your ADA obligations are, your what they call accommodation that is required of you as a place of public accommodation as a retail business in order to comply with the ADA. So that's your fun news for this Monday, November the 2nd. But if you have any questions, you can feel free to go through the help desk and we'll be happy to point you in the right direction. But it's something you should look at because like I said, there's a wave of them going through right now. We've had 3 clients here in Southern California who've been hit with these. And typically it says, I'm blind and I tried to access your website on such and such date and I couldn't because I couldn't hear any of the products or figure out how to get to your store. And so pay me $6,000. and fix your website. They always make that a condition as well. So you'll have to do it anyways. Plus, you get the pleasure of paying a lawyer and his shakedown artist client some money as well. So, anyways, that's your fun news. Have a happy November.
Okay, great. So we invited Rick to come on the call today to talk a little bit about arm braces and what's going on around the country with these arm brace, the arm brace controversy, and are arm braces banned? And arm braces are always an issue for you guys out there, but it seems to be in the press more and more this week. Whose arm brace is verboten, whose isn't, what's going on? Rick, you want to pick up a little bit where you left off on arm braces, and then Chuck, Matt, Josh, you may want to chime in on how it touches on California, and let's just open the floor to some conversation because it's interesting.
I'm going to do it just like I did earlier, just take a few minutes, but start out from the beginning. ATF had 30 years of denying arm braces because everybody knew that once they got into market, they were going to be used as stocks. And then Alex Bosco with SB Tactical brought in a disabled veteran, and they approved it. And no one in ATF wanted it approved. Farms Technology Branch didn't want it approved. The attorneys didn't want it approved, but ATF headquarters got it approved. So that kind of how the animosity started. So the first couple of letters, they're pretty bland. This are an arm brace. That's about what it said. Then the discussion came out, well, if I use it as a stock, is it a short barrel rifle? And you had contradictory letters until once again, ATF headquarters penned a letter that said, if you use it as stock, it's not a redesign. It doesn't make it a short barrel rifle, but if you want to use it as a short barrel rifle, you should file a Form 1. So everybody interpreted that as an arm brace is a tax-free short barrel rifle. So people started getting arm braces approved, and others just got arm braces made that they thought was in line with what ATF made. And there's no written criteria that says the length of pull must be 13.5. It must be able to be lined up with your sights. It can only weigh so much. It can only be so much color. So, or a different color, just throwing an attribute in there. So the Kellen Wright case came up, and I got asked to testify in that, and ATF came up for that case, the 13.5 length of pull, and they measured it at an angle to get 13.5 inches. But of course, ATF lost, and we defeated ATF in a federal court. So ATF got really upset and just started coming out with arbitrary determinations when you sent one in to be approved. So if you send an arm brace in, ATF puts it in their arm, and then if you can't line up the sights, they say, well, it's not an arm brace because it can't be used to aim in. If the rear is too big, they say that's so big it can be used as a stock. If it's too small, they say it's too small, your arm doesn't go around it. So this is the criteria that ATF was using. So SB Tactical is the main manufacturer of these arm braces, and SB Tactical made some, got approved, SB1, SB2. They never got the SB3 approved and others, and they just started selling them. Well, DOJ wrote a regulation against ATF saying that you could not basically write criteria against this arm brace and basically making it a criminal offense. So what ATF did said, okay, we won't do that. We'll wait till you sell it. Then we'll have an agent go pick it up. Now it's a criminal matter. And if it doesn't fit our criteria, which there is no written criteria, then we'll call it an arm brace. So it started with Fostech, and they had to recall all their firearms. Then it went to Kalashnikov USA, and they had to recall their firearms. And now it's with Q and the Honey Badger. Well, Wiley Reen has gotten involved, and Mike Fawcett is the attorney, and they have big lobbying pull in DC, and they got an associate deputy attorney general to listen to them. So ATF has been forced to stop this cease and desist for 60 days. And no arm braces are being evaluated now. So no matter what you have out there as an arm brace, there's no criminal action against it because ATF has been told by DOJ you can't do anything. Kind of in a nutshell, if Trump gets elected, then this matter will still be taken up by DOJ and we'll probably all benefit from the termination. In between calls, I went ahead and called the attorney that's handling it, working with DOJ right now. And ATF has been removed from giving any criteria. DOJ is now writing criteria like they did on the bump stock. So they are writing criteria, but that doesn't mean anything till November 3rd happens. Because if Trump wins, then they'll continue to do what they want to do. And there may be no criteria on arm braces, or they may say, if you make it to this dimension, it's an arm brace. And of course, if Biden wins, then we don't know what's going to happen. So basically, if you have an arm brace now and you don't have it's not grouped in one of those three companies that have a recall, I would just continue to sell it, use it, and wait till the 60 days elapses and see what DOJ says. So that's kind of it, all in a quick few minutes.
So Hank, we spoke earlier, you wanted to tag on to that thought with some of your own thoughts. What do you got?
Yeah, so, we've been talking about like the website stuff, setting yourself up for potential, violations if you don't make your website ADA compatible. There's another thing that I really want to speak to, and I've not heard a lot of retailers talking about it. I know we're not going to see a big change in inventory levels here in the next 30 days or anything along those lines. But what I can say for sure, just based on the history of this industry, that if the election tomorrow ends up anything close, there's already, evidence out there already showing that lawsuits will be put in place to contest the election. And we know that anytime there's any level of national uncertainty, what is happening in this country, the interest in firearms goes up. But if we don't have any more product, what does that mean? Well, what it means is you're going to probably be seeing a huge increase in traffic flow in your physical business, and potentially for the next 30 days. Because if this gets put into the courts and goes to the Supreme Court and all this kind of stuff, it could run all the way to December 14th, which is the certification date for the election, which could put us into a 30-day window of heightened uncertainty as to what the presidency is going to look like. And again, if nothing else, it's going to drive more human beings into your physical store. And with current regulations on occupancy rates, mask wearing, all that kind of stuff, if you don't have a plan in place now, or at least by the end of today, so with the election being tomorrow, you're just setting yourself up for all these type of litigation groups that are going to say, oh, the people weren't wearing masks, or they had too many people in their store. There is very likely going to be a large wave of physical interest of coming into your store here on the tails of this election, potentially for 30 days. And I just implore everyone on the call to sit down with your teams today and figure out what your customer flow strategy is so that you don't get into these sticky wickets with folks reporting your store for being in violation of any of the regulations you have in your areas due to COVID right now.
And interestingly enough, I have to say, and Chuck, I don't know if you even knew this, but the place where I see the most snitching going on is in California.
Snitching about not wearing masks and
Snitching about everything. Disgruntled employees snitching to ATF about what their former employer did. It seems as though all these, so I have a decent rapport with the ATF field offices in California. I always get backdoor information of people who know who my clients are within the ATF field office saying to me, hey, what's going on over at such and such, or what's going on at so-and-so? It's always in California. So I don't know whether you breed snitches out there or what's going on, but
we do.
Okay. All right.
Everybody thinks, they need to make the world better for themselves by ratting other people out, and they make a lot of stuff up.
Well, that's, yeah. Well, I get that, and that's the That's
And
the,
that- I was saying that's my point in all of it, though, is to not give these folks any extra ammunition by not having a very well thought through, traffic plan for the next 30 days.
so interestingly, Travis has posted to everyone at Guns Fishing and other stuff about having to put together a plan to keep the Dublin store open. And you look happy, Travis. You're smiling. So
I'm
give us a
smiling
little,
'cause we're closed today.
well, give us some background on what's going on.
Dublin, when this all started, required us to put together a traffic plan, a flow plan, and everything to keep the store open in Dublin. 3 months ago, in the middle of all this, they decided, well, you need to shut your range down. And they shut the range down until a week ago. We finally got to reopen. And we had already had all the plans and everything submitted to them.
So it just sounds like they were playing with you.
Yeah, they don't like me too much down there. Alameda County Health, because I've stood up to them twice now, and I've won once.
More California nonsense, Chuckles. It's the way it works. It keeps you in business, I guess.
Unfortunately.
So to that end, that will wrap up our half an hour for California. We will, of course, post this if you want to show it to anybody else. This whole video will be posted at some point before Friday. We will have a more detailed review of arm braces from Rick and others by Friday. And hopefully we will still have President Trump in office on Friday, although like Hank says, we may not even know. We may not even know who's the president. What we didn't touch on today, and we should have, is the, and I'm sorry, I forgot this. This was my lead-in in the federal seminar, so I forgot about it, but you all should be using a new 4473 as of yesterday. And if you have any of the old 4473s, they better be in the garbage. Because I assure you, if you put the date of November 1st or 2nd on an old 4473, you will get a violation. You are handing an inspector a violation. Really simple. Get rid of the old, out with the old, in with the new. We have training modules available in our website for you to let your personnel review. One of the more comprehensive trainings is usually at the 200. So we have 100 level and 200 level, like college. The 200 level 4473 training is usually a pay-per-view, pay to play, but it is free to all of our clients for the next 90 days in order for you to get everybody trained up. So please do take a look at that. If you have any questions, you know how to reach the help desk. And otherwise, Chuck, are you raising your hand to add something, or are you just scratching?
Just scratching.
Okay, yeah, we're all itchy at times. Brian is raising his hand. He's always itchy. What do you got?
You do, well, there's a pill for that. You do have to get rid of all your old 4473s unless you are currently in the middle of one. Someone is on their waiting period or whatever it may be. Any form started October 31st or earlier, if they're on a delay or if they're in a waiting period, those forms are grandfathered in. They are grandfathered in. However, if the transaction began on November 1st,
it better be on a new form.
Better be on a new form. That's it.
With that said, we will reconvene a month from now, same time, first Monday of December. Hopefully we will know who the president is by then. And in the meantime, stay safe, and we will catch up with you soon.
Thanks, everybody.
Bye-bye.
Bye, everyone.
Thanks, guys.
Yeah.